with it. I am aware that the ICF, I did receive an email, it's one page with what you said. It's I have to flip it. So give me a second.
Okay. Just for the record.
I'll have to finish my part. Okay? Because so it says, your ICF says the state secretary witness who did the inspection on the vehicle in this incident needs to be recalled. The Wednesday, I just learned of some information that is so I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was certainly well known. I'd also note the vehicle is registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of the information before us by way of fact or even an offer of proof that even she received that information, did nothing with it, or whether anyone else who operated that did anything with it or not. Bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And my understanding and review of Exhibit 83, important in this case is that the inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident question. I'll accept the state offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by offer of proof, I can't make a finding, number one, there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness. Hold on. Let me have the state. Go ahead.
Mr. Schultz's medical inspection report was provided on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and answering questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that gave me the information. Information of this. I had no knowledge until that's how I came into the information. She was the one that said, I'm going to send you all the information that you need. You can present it to the court. So
this wasn't your request is timely. So you have had this information for some time, either through counsel.
I did not have
either through counsel,
just told to me.
It's not. You've had the information in court for quite some time. Prior counsel through all of because of the inspection that was done, and had a full opportunity to cross-examine information that was readily obtainable and researchable by you prior to the time that you cross-examined witness.
It was not really available for me to at the time. I don't have access to the internet, but I'll be able to.
Mr. Brooks, you're telling me your mother had information.
No,
so
she just told us information. I have phone calls.
I understand that. I'm denying the request, sir.
And I would like a.
That decision.
I object to that, Your Honor.
I understand. I've made my decision. I expect that you respect the decision, at least as we're not going to debate it further. I
Honor.
to the state.
It
Madam
needs to
Clerk,
be
I just
addressed.
gave. All right, so,
I
Mr.
respectfully object, Your Honor, and request a legal consideration of your ruling, Your Honor.
Request for reconsideration. Legal base for me to
Respectfully take exception to that ruling, Your Honor.
Ms. Sweeney, keep going.
For the record, request a legal or factual basis for your ruling, Your Honor.
I provided an oral ruling. The record stands, sir.
For the record, may I respectfully request a written judicial finding of law on this issue.
Denied.
For the record, may I respectfully move for an declaratory appeal of this matter.
I wouldn't be the one you would make that request to, sir. So I can't answer
Ma'am,
that. Yes, sir. Request denied. What other request I'd like to?
There has been, Your Honor.
The request is not a proper. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, appeal. Show me how or where this court is following the law, respecting it.
It's a very vague statement. There's no legal relief that you're claiming. There's no motion of the court. Fact, so this court cannot address that statement of yours.
Your Honor, respect. Finding the fact.
Denied. I do so.
A motion for how do I know?
Mr. Brooks, we're going to move forward. At this time, I want to.
How do I know that this is, Your Honor? Can you show?
Mr. Brooks, we're moving forward. The request is
like
denied. Mr. Brooks, I need to give you some advice. Sir,
I need to do your with
because now he's facing the court's something around this. You have to call. You have a witness.
Actually
is required by
need to do your job.
Mr. Brooks. I need to go through these advisements and keep interrupting. Forfeit your right to move to the next courtroom so that I can properly go through the eyes without interrupting.
And I still don't answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've felt that you have forfeited your right to be present by your conduct, which is the options available to this under Illinois versus Allen or State versus Vaughn. It's also referenced in State versus Anthony. So I am going to go into your protestations.
Your Honor, with all
I need
due
you
respect,
to not interrupt me. This is another interruption.
In Illinois versus Allen.
Mr. Brooks, I'm not going to have a debate with you on the meeting of Illinois versus Allen.
Have a debate.
You are advised that continued, Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've said multiple times, I've given you multiple opportunities to stop interrupting me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding you
removing me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus
Alan to this
I'm
court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even in a mild manner,
Understand, Your Honor,
standards of
because it
formal
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that
remove him to the next courtroom so that I can go through
it does
proper
not state.
advisements with him without being
It does
interrupted.
not
We'll
state
clear the courtroom
that
and
you
we'll
be present from
once he
cameras.
is over there.
It
Again, I'll make
doesn't
the
state
appropriate
that you can be
findings when we
present
get there.
cameras. That you could be.
Yeah, cross the record
That you
until,
could be
his
for attack an agreement. Something that
Madam Clerk, indication that the audio and video are working in the neighboring courtroom. All right, thank you. I do have verification. Our headphones on the table. Mr. Brooks, did he choose? He's reading from a book. I need to make a record this morning. Although were repeated interruptions, he wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss, recall a witness, he then asked if I for written findings. I denied that. He then asked for what law I was following. I indicated all of those. Court to a request would be made, something that would be made to the Court of Appeal, and although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in the courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least. Of course, on the record for this court over the first 15 days of trial, where Mr. Brooks had his conduct forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he yelled at me. He didn't raise his voice. He didn't speak in an angry tone. But given the history in this case leading up to today, knowing what this means to get through, whether he has witnesses, whether he intends to testify himself, very important. I need to have advisement of his rights that I took through. I simply not able to do that with him constantly interrupting me and not respecting the rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to the courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and inherent concepts of court judicial proceedings. I, of course, have repeatedly, even without him such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he at many times has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom, if not during the entire time. He was able to examine witnesses. We had a couple of issues during the testimony of witnesses he called, and of course, last Friday was, in my opinion, probably one of the challenging days, I should say. I hope that we can continue with Mr. Brooks in this courtroom at some point today, certain back over when I get through these advisements. Mr. Brooks, you have been, I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
when I was just over here? Are we addressing jurisdiction?
I'm going to mute him just for a second. No, not to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the
whether he has any witnesses to call other than himself. He has declined to answer that question, or if failed to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response. Well, me muting you, you being mute your the a mistake bail. Because you interrupt court. So I ask you another way, even though for 3 times now he has failed to answer court. You indicated last week that you to call witness Dawn Woods. Were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you Woods as a this morning and specifically now? Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. I will instruct a third time for the record. He's finally putting on headphones. Do you, Dawn Woods in the courthouse available to testify right now? Intend to call her. For the record, he puts on the headphones when any other court he does not put on the work fine in that courtroom.
In the courtroom, I don't need to be muted.
Mr. Brooks' statements that David when mute him is simply false. I confirm
My audio is not working, so you need to stop lying.
not on the records. He's going to once now. He's raising his voice. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods because he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. based upon his failure to respond upon court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence. And also with respect for the dignity, order, and forum that is in the courtroom. Mr. Brooks said this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject jurisdiction, which the court has previously found simply a distraction tactic, delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses, I find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I'd ask Mr. Brooks to put on his headphones if he is unable to hear me, and to be 100% safe and secure on the record. I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him. If you're unable to hear me, to put on headphones at this point. He's unmuted. I also advise by not just the bailiffs who are over there who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and also advise that you have a constitutional right to testify. Did you hear me say that? There's no response. Mr. Brooks, and he does not have that. He has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? By Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you and advisory. Did you advise you that? No response. To testify is for you alone to make. Say that. Mr. Brooks had a grade education, that he attended school either up to or 12th grade, and either has paperwork. I'll find a he's Waukesha County. Sir, have you taken medication within the last 24 hours or any drug or any alcohol? Not to that. He's able to read and write English. I would refer back to the record during my plea with him regarding the will of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including right, I'll make a finding he has the ability to read, write, English. I'm sorry.
Station C on right now. You're actually from the for the Bible is
able to upon functioning, not respond. Has it made any problem influence your decision?
You know I don't cut the crap.
Words at this moment, I believe that he is feeling his inability to hear. He's done so throughout this. There's absolutely no indication he puts headphones on when he wants, he puts them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them in the other courtroom. But again, I've confirmed multiple times the audio is loud and clear. His statements that here when you are he heard me say that to make with his statement. Again, once again, for the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision? In this case, by going through the proper colloquy with him regarding his right to testify, asking me about subject matter jurisdiction, jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and disrupt them. I will unmute him and ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond no, and that he is not going to testify. So once again, I'm unmuting him. Sir, have you made a decision on whether to testify in this case? Another way to testify on your behalf in this case. Been. Sir, do you
because I haven't heard that. So how you ask me something and then take
right? Again, and it is very clear to the court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears the court and if he uses it to willfully this court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make appropriate findings. Without him providing answers, this left no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's conduct throughout this trial, his repeated defiance, his repeated rules of decorum, interruption of this court, and this court repeatedly remove him to the courtroom and making findings that he has forfeited his right to be present. Of course, this record is above at this point that Mr. Brooks has not been in the main courtroom because this morning alone he is yet to conform his conduct to the standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent adherence to the including rules of procedure, rules of pledged by these things, then on balance, this court will find that he forfeited his right to testify. I've now made much more of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but is Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Are you aware that you have a constitutional right to testify? Mr. Brooks, I'll do another way. Sir, you are that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't.
He is willfully choosing not to answer. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
Questions for I didn't hear you ask me anything.
Stop talking and I'll ask it again. Sir. This court has simply tried to fail to get Mr. Brooks questions confirming advised that he has a constitutional right to testify. And he also has a constitutional right to to follow the rules of decorum and civility and not interrupt. He has done nothing to demonstrate to court. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about intellectuals, etc. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer questions regarding his right to testify, whether he heard that or not. And based upon Pursuant versus Anthony, and looking at the balancing test that this court simply cannot allow Mr. Brooks to get on the witness stand unfettered, without acknowledgement. Will evidence that are made by the court repeatedly throughout this trial, and this court that he disagrees when looking at State versus Anthony, this is a case where the Supreme Court was with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was removed courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without regard to the events and the rules of procedure. As State Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony.
Stations at Deirdre at ABC. Heads up. It looks like on live channel 4, the new prime minister in the UK is about to speak. Television, okay, for the station. You need to have your own unilateral APT.
Relevant.
WXYZ.
To testify. Thomas has repeatedly accused this court of violating his First Amendment right of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that he may fit right to testify by his conduct, whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, or the rules of evidence, of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout the trial and based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer questions would be taken as by this court really as no, meaning the specific question, you made a decision, and is for all those reasons that this court will make a finding he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask if you want to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back so he is present in the court advises the defense. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring it back over. Are you willing to make that pledge, sir?
You know, trying to you ask me a question I can't answer.
No, go, sir.
It's about my right to remain silent. How can you remain silent? So you're not going to protect my constitution? Because I didn't add nothing that you was trying to ask before when I had the headphones on, and you can't make a decision for me. You can't violate my constitutional rights.
Sir, if you'd like to testify, then you need to go through this court, which I've given you 3 opportunities, and you have decided not to.
When I know, you can't tell me what I decided to do or not.
Are you willing
By law,
to?
Your Honor, by law, court.
You, sir.
I did not say myself.
Last Friday, please directed your attention to State versus Anthony. I discussed very briefly and unfairly the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on this.
Did you know what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent, entire procedure, is noted for the record. Based on his inability to pledge to the court that he will honor that ruling and respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom, and the appearance from the courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have, I anticipate, will be a very lengthy discussion on jury instructions. Again, I will advise if he wants to come by people of civil, and he specifically of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out. Thank you. Be seated. Ladies and gentlemen, this is a court him in any, and not influence any matter. I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
Rebuttal, Your Honor.
All right. And with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions. I anticipate bringing you tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing and have the case be turned over to the jury. If not, by tomorrow evening, sometime Wednesday morning. With that, the jury then concludes to back to you during the we begin, I will have at least be come break. I'll invite Mr. Brooks to come back, and then we'll start with that jury instruction. Take a few minutes. We are
Station ABC on live right now. We're getting NNS from St. Louis, where two shooters have been injured in a shooting at a school. The district says have stopped the shooter. Source again is KDI, KDNL, mandatory credit is making real and Lionel 3 now.
the appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked as well. All right, we have Kibler, if you could take the witness stand, please. Sir, could you please raise your right hand? Swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. It is. Thank you. Have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Cholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was from this courtroom to that courtroom?
I was.
And did you make any personal audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom the name.
I could.
All right. Make a statement.
Yes.
On the occasions when his microphone was muted, the audio in the courtroom continued to work.
It was.
At any time while Mr. Brooks was muted, or even if he didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. Prefers out in that court. Did not come back here.
All right, thank you. Those are all my questions.
Mr. Brooks, you're unmuted. Do you have any questions for this deputy? All right, thank you. You may step down. All right, I'm going to have Zach May also take the witness stand. Project. Yes. Right. There is, first of all, sir, stand and raise your hand. Do you want to state the last name for the record, please?
Zahary is TREAI.
Right. And what is your position with the court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County.
Were you in courtroom 20 this morning following Mr. Brooks being taken to
Call started.
a document or photograph that's displayed on the monitors throughout this courtroom? Can you tell me what we're looking at?
So in the photo, overlay on top of what we call it is our AV control. We push buttons on it and actions happen in the courtroom. AV. At the top of the photo, my phone is registering 67.3 in that courtroom, and that was when the judge or the court was talking, and the sound was going over the speakers in the other room.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
For comparison, I did a quick reading in the room, which is CG6. The meter there was 55 and 65. So it's louder than the audio feed going to the meter right now.
Right, any questions?
Sir, looking at when you're on record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right hand, the time is either 26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the time of 9:23, I believe that needs to be updated, but
Okay,
it is approximately 9:06 when the photo was taken.
okay. Do you know what happened in this room?
I don't. I'd have to say before talking.
Thank you.
Mr. Brooks, any questions for this witness?
For the record, I don't consent to being called that name. Anything about the hearing was hearing loss in years. So it'd be no everything good. Well, I can see with photo that every that was
I'll show you in a different, I don't have the Zoom up and running, which would be the mechanism to allow for an exhibit to be played. I can set that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up. Can you step off through the Zoom so I can screen the exhibit, which will actually help during.
Are you calling? Okay, good.
Except now both systems are out, so hold on. So the screen. But that'll take me just a second. And your screen, so the color exhibit by the defendant. The images being displayed. Thank you. Questions regarding that? Okay, I'll stop sharing. Okay, thank you, Zach. All right, I just wanted to put that in records. That was an issue raised by Mr. Brooks previous. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record to reflect that Mr. Brooks provided with 100 pages, and this is provided with a copy as well. It's all the same, 107 pages. My written copy is on its way. Your request. Request is noted. It's denied without further hearing or consideration.
Every issue is supposed to be closed. On the record. Evidence. I haven't yet to be able to offer exhibits into the record for evidence. How is that so?
So the court did declare the evidentiary phase of this trial closed. They specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure, rules of evidence. To you wrote all of those documents, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me. You told me to present myself first. I had everything out and present the court.
So that's what I said. You're misquoting me, but in any event, denying your request, I said.
So you're saying that I have no right to present evidence as
Mr. Brooks, now I have a debate about.
You're right.
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial You forfeited your right to present further evidence and testimony previously by refusing to answer the questions. I will speak to the filings. It is not true that any filing would become evidence. That's simply false. Two, motions be written down should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth that would allow this court to admit his written filings. I believe irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will mute him. He clearly just took the entire packet of jury instructions, put them on the table, just simply put them under the table, but they're no longer in front of him. However, we can get his feedback regarding jury instructions. Typically a back and forth. We'll go through them. And I'll ask the parties whether there are instructions they believe should be included, and we'll have a discussion on that. And we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
You're unmuted now, as long as you
can't. I'm not. How can you not with this information that told you to be presented in? So you filed it. You everything that I gave you.
Mr. Brooks, need to mute you because they're not relevant at this time.
It is.
His tone of voice, he's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. Made ruling. I determine you have the right to testify, which includes the right to present evidence as you would have testified. I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based on your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings, reference the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction count. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. Unmute him again, but you are advised, sir, you need to be proper, corrupt, and you need to task, which is we're discussing not other evidence, not subject to jurisdiction, not belief that I do to things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
I will mute him again because he wants to continue. And again, I understand he's upset. I understand himself his ruling that I. All right, let's go through these jury instructions. of all, receive.
Yes, Your Honor.
Thank you. Mr. Brooks, now see if you did by acknowledging previously, but you acknowledge receipt of the final jury instruction.
I didn't acknowledge nothing, and I don't acknowledge I received anything.
To
I
pick
don't.
up the from put them in front.
Put on
Right. To regarding his forfeiture by conduct of his right to present further as on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amended edition on count 70. Uh, 76, the 76 count. That's near what is in there, but that was one question. All right. So, do you have any requests to the jury?
Your Honor, I'm just, what, 50 of, everything's looking so far.
There's 107 pages. I certainly can give the parties some time to continue to read through them. Mr. Brooks is requesting back to his cell. He's muted, but I can certainly appears to be yelling at the top of his lungs. I can discern what he's yelling. without a specific to be present. It's from the remote. Remain in that courtroom. Now require him to follow me with me. But I would ask you to specifically advise any specific jury asking be read to the jury. Categories of instructions that you believe this court should consider, and write them down. A piece of paper. If you don't have, by writing it, I'm not sure if I see a pad of paper. We'll make sure you have that. But give your current demeanor, which is still seems quite animated, and a loud raised voice, I ask that you write it down. doing this review? Okay. I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, tone of voice and volume level that he's using from the neighboring room. But they just put them in the numerical order. So hopefully I haven't taken out any numbers. Yeah, there should be numbers. There are numbers. Well, there's some like the ones that all. That's just the easiest because this goes after credibility. And then it's for any specific for either instructions that you want this court to consider, please note to the
Station security, which source again, Newport, Louis school shooting.
I know in my review, I noted a few spots that either in the heading, submission, or words that might need to be removed. But want to go through and tell me requests you have starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail. I know that we had charged 2 separate felony cases, and it was one bail. And I do believe it's sensitive to the jury to have the specific case number. So when we're first talking about 6107, we start talking about the bail jumping. And then we go specifically on page 63 of 107. We come up with 74. I think might be the one because case numbers, what they're finding, and that as conditions, and those bonds were entered into.
We look at the information.
Just, I think this was just for 207 for the bail things. Three separate 75, 76. There should not. I believe that should be the pattern.
I'm going to see the information it says. And then I'll ask as a position on that. Sometimes it's, we just, I guess, changes requested. I'm going to some notes and then we'll
Sure.
go on. But
I believe it was spelled out in the amended information. I don't believe it was spelled out in the amended information. So that
like right now, all of the information. Let's go list and then we'll get
okay.
the defendant's responses if like those.
Of 107, there's accounts details that is available to the battery. I did the motive instruction was incorporated on page 7. And I know that intent is, I don't incorporate loan instruction. The court incorporated it with first degree intentional disorderly that was.
I think that's the instruction.
Oh, it is. Then we'd ask for motive. I think that there's 175 instruction that could be given.
I'll look at that.
And then on page 65, which is the preliminary instruction, proceeding pro se, there's the standard paragraph, which is the first paragraph listed under this instruction, and there's an additional paragraph. To that additional paragraph, I think it highlights the defendant's bad behavior, but I ask that that be taken out.
Right, know that, keep going.
Okay, with regard to page 106 of 107. I believe that those were added at the end that the court wanted to.
Yes.
I believe that there was 325 should be. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that page 106 of 107, instruction 41, where identification of defendant is an issue. I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people if they were able to see the person driving, description of the person, they would cross-examine them as to their ability to perceive that. So I guess that would really be the difference if he wished that to be given. On 107 of 107, instruction 172, circumstances
Like though. What's that number?
172.
Yeah, I know, it's not there. It's fine. But on flight, I made a correction. I'm just gonna find it.
Because he took off some clothes that would have identified him. But again, is trying to be by clothing that would have been identified by as him light top.
Are not in the packet that should be.
No matter.
Right, let me turn to Mr. Brooks just to get whether he has any list. Not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your request. Do you have any requests as it relates to instruction? So I can't see his jacket. See the jacket. As relates to the draft jury instructions, whether that be additions, or edits, or deletions. Here, I'm gonna, I can see the Brooks. Behind there. He has quieted down. He hasn't, I haven't heard him in a while. You move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask, do you have any requests that aren't from the he's not. I'm asking him, and I commit 5 days request
See, I'm just looking down the
answer.
said it might be for a life.
Audio is turned off. You can hear me. Chosen not to provide choice. My final question to you: do you have any requests to the jury instruction? Headphone. So agitate for you. Mr. Brooks has your what request has the jury instruction, sir? Disrespectful again.
You been being you been being straight.
I need to know what your position is with the jury instructions, and I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests that relates to the jury.
Yeah, first of all, my charge with 2 bail jumpers when I charged walking for the same double jeopardy.
That's not jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge I already charged with? The fifth of
A legal that is that your objection is noted, but the jury instruction regarding the bail judgment.
the law, you charge you cannot
What next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? Always want to get always trying to
Understand your position. The bail charges in Waukesha County are based upon your buying your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others. That's the distinct. The same offense. It doesn't mean the same actual basis, sir.
He is charged of 21 Milwaukee County anywhere for the double jeopardy prohibition to prevent him from being convicted. It's not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instruction?
I want to know why I'm saying they charge me in a case in Milwaukee that I'm only charged with bail jumping. I'm only charged with bail jumping.
It's a different. Related to the allegation of crime in Waukesha County on from the Milwaukee County. My understanding, sir, is there's different types of violations that relates to that. So noted your objection. I understand it. Your requested, I guess, dismiss the bail. There's
Am I not being understood? They charge me with the same charge.
two sides, sir. There's
Is it not? Is that that refers to
going to have and fruitful. I understand what you're saying. There should be 2 counts of jumping. You believe it's double jeopardy. I disagree with that. There, sir, it's changed the fact that my perspective, the 2 jumpings are going to proceed forward. There's been sufficient evidence to warrant the jury being instructed.
they can't.
What other requests do you have, sir?
Talk over me. Don't talk over me. Just like you want me to talk over you. Just like you don't talk over me. Just like you don't
Mr. Brooks, what request do you have?
I just asked you. You can your know you. I didn't write nothing over there. No matter how because we both
Instructions. What objections are noted? Understand that?
focus my attention.
Answer on. I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. Just made an argument regarding the bail jumping, so clearly has an understanding about the law relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through the list. I need to get through their list. I'm asking you to